in my thinking process. So let me see if I can share it. Okay, here we go. Okay, so I believe you can all see it. Can you all see this presentation?
Yes,
Yes?
we can, Professor. We
Okay,
can see
good,
it.
good, good, good. Okay, so I think it's very important to emphasize the role of criminal law in the legal system or in society in general. Of course, criminal law, and I'm not trying to undermine the role of other branches of law, private law, and others, commercial, whatever. But I think criminal law is, in my view, the backbone of any legal system because it touches on very important issues relating to individuals in society, the rights and responsibilities of individuals in society. Yeah. It also deals with issues relating to accountability, protecting individual rights, promoting social justice. So to me, not because I'm a criminal defense lawyer and I very love criminal law, but this is a fact that criminal law really touches really every point in our lives, in our everyday lives. So I think this talk is going to be timely. It's going to remind us some few things that we need to take to think about as we discuss this topic. Obviously, I normally have been teaching for more than 20 years, so I normally tell my students that while I am older than you and probably have more degrees than you, but it doesn't mean I know everything. I normally like to take this opportunity to also learn. So I will speak for about 30 minutes, and then I will leave the rest of the time for questions and answers, and see also what your views are on this topic. So this is my roadmap. This is how I'm going to structure my discussion this afternoon. I've already started with my introduction. So there are these questions that I'm posing. What is the importance of criminal law research? What are the advancements in criminal law research? What are the strategies for effective legal writing? And then I will conclude with some reflective conclusions. So as I said, the criminal law research is significant, and criminal law generally is an important branch of law because it shapes the legal system, it assists policy development, and basically provides a functioning society. And it is also a fact that criminal law is advancing. And that's why, to me, this is a very interesting branch of law. Criminal law is advancing, and the possibilities are immense because of the technological advancements that we have today. And therefore, I think, again, criminal law as a branch of law, of the discipline, is important. So what is the importance of criminal law research? So there are a number of things here. I just picked a few just for discussion purposes also. So the importance of criminal law borders into issues of justice and fairness. I don't know how many. I do pro bono briefs, and I go to committee prison all the time, most of the time. And when I get to committee prison, when I'm visiting my clients, the people I see there, I can conclude are people of uh, ordinary means. I don't like to use the word poor, but ordinary means. Okay. So the question becomes, do people in the Republic of Kenya who commit criminal offenses are only poor people or people of ordinary means. Yeah? So that's something to reflect on. So it relates to issues of justice and fairness, of course, policy development. We have to make sure that all policies are scientifically driven, okay, research driven. So like you guys in the law journal are doing exactly that. The attempt is to generate research that would eventually influence and inform policy. Crime prevention, okay? So we always come with these ideas about crime prevention. You all remember in 2015, the Security Laws Amendment Act, when it was debated in Parliament. And the parliamentarians argued that we need the Security Laws Amendment Act so that we can respond to terrorism acts. But the question is, was there any empirical study that was done on whether there was a need to have a different policy or an additional policy in the prevention of terrorism? We already have the Prevention of Terrorism Act of 2012. Also legal precedent. So we all know we belong to a common law legal system. The premise, the baseline, the premise of our legal system is stare decisis precedent. So criminal law research also makes a contribution to legal precedent. It allows legal scholars like yourselves, you know, researchers and others to also make a contribution in creating the criminal law jurisprudence. Issues relating to human rights and civil liberties. These are straightforward issues. The criminal law has a huge role to play when it comes to issues relating to human rights and civil liberties. Wise to remind you of Article 49 of the Constitution of Kenya that provides for the rights of an accused person. All those belong to the Bill of Rights in our Constitution, the Constitution of Kenya 2010. Issues relating to reform and rehabilitation. Okay, Paula, are you asking a question?
Just a concern. We cannot
Yes.
see your slides moving. We're wondering if you're moving them.
Oh yeah, I am moving, which we are on slide number 4 now, which is what is the importance of criminal law research? Are you seeing that?
Oh yeah, we missed the other ones. Yeah, thank you so much. We can now see it.
Okay, yeah. So you know, with technology, we need to be a bit patient. I really like face-to-face things, but with technology, we need to be a bit patient. Okay, so that's good feedback. So if you can't hear me or the slides are not moving, please let me know. And I've also logged in twice, so I can see my other computer here. So legal education, okay, exactly what you guys are doing, your law students, and the expectations are you'll pursue your legal education. Some would choose, perhaps elect criminal law to be an area where there will be expertise. So basically, the list is long, but these are just, I think, few of justifications of the importance of criminal law research. Ethical consideration, I can't emphasize that much. Issues of ethical considerations are important, especially now in the time of technology advancements. It's very important that we take to account issues relating to ethics, and also the introduction of some mechanisms in the criminal justice system for the purposes of bringing criminal law disputes to finality. For example, plea bargaining. Okay, so what's the ethics of plea bargaining? Yeah, here you have on one side the state, okay, that is very powerful. It has all this machinery, engaging through the prosecutor, engaging in a discussion. It's called bargaining, but I don't really know whether there's really true bargaining here. You have an individual person. In most of our communities and society would be a very poor person who doesn't have financial means to even hire an advocate to represent them, and you are telling them that they are engaging in a bargaining here. Yeah? So issues of ethics cannot be overemphasized here. Okay, let's move on. So what are the advancements in criminal law research? There are many. Again, my list is just to strike a bit of a curiosity. I see it has not moved. I am in the next slide and I can see in my other computer it's not moving. Okay, let's see here. Okay, it seems the system is very slow. So you guys are not seeing the slide that I'm projecting now. The slide I'm projecting now is on the advancements of criminal law research. So you can just listen. When it shows up, it will show up. Now, there are many advancements in criminal law research today. And I also believe that the legal training in the 21st century has morphed and changed into something very more complex. When I was going to school in the late 1990s as a law student, the training we received is incomparable to what you guys will be receiving in this time and age. So some advancements in criminal law research involve neuroscience and criminal law. Okay. We need to be able to understand, why do people engage in criminal offenses? Yeah, neuroscience is a discipline, is a subject that deals with brain function, okay, brain development. In fact, this is where we base our arguments that juvenile offenders or children in conflict with the law cannot be subjected to the normal criminal law. All right, so because the idea is that their brain is yet to develop to the extent that they can appreciate the nature of their actions. Okay, so neuroscience and criminal law is one of those advancements in criminal law research. It reminds me there's a subject called criminology, and in criminology, yeah, I think maybe you have a unit in your curriculum now. But criminology is a social science. It's not really a discipline, is a subject of law, but it's a social science that attempts to understand why people engage in criminal offenses. So there are a panoply of theories. Okay, one of them is from the so-called biological school of criminology. The father of the biological school of criminology is a scientist who conducted research in the 17th century. His name is Cicero Lombroso. Okay, so Lombroso conducted research in a prison in Italy, and in the conclusion of his research, he stated that he came up with a typology of criminal offenders. He said that criminal offenders can be viewed by the physical eye. You can look at their appearances and conclude that these individuals are criminals. Of course, that research has a lot of problems. Today, we can see it as problematic, and some have argued that it has contributed to problems relating to racism and others. But it was the first attempt to be able to explain, okay, why do people engage in criminal offenses in a scientific way. So neuroscience and criminal law is one of those advancements in criminal law research. Big data. They say data is today's gold. Okay, and data drives these decisions within the criminal justice system. Yeah? For example, predictive studies. Okay, predictive studies that are used by police, for example, profiling. Okay, profiling is not necessarily illegal, but it depends on how that profiling is done. We have two types of profiling, what we call hard profiling and soft profiling. Hard profiling is the one which is illegal because you are looking at physical appearances of the individual, um, their ethnicity. Maybe they look Arab, they are between the ages of 25 to 18 to 25, yeah, and then conclude that they probably are suspect. Yeah. But soft profiling is not illegal, and profiling has been used by law enforcement for ages because it helps to predict, and therefore we see here the advancements of criminal law research in the area of predictions within the criminal justice system. Other areas are like criminal justice reform. Uh, uh, Criminal law obviously plays a significant role in making sure that there is criminal justice reform. Yeah. So that issues relating to rights of individuals who come into contact with the criminal justice system are taken care of, while at the same time reflecting on their rights as individuals. And we all know these presumptions that are embedded within the Constitution, the presumption of innocence, among others. Another advancement in criminal law research is in the area of DNA and forensic science. Okay. And that's why probably the lesson you would pick from my discussion today is that law is becoming more and more interdisciplinary. Okay. Again, as I said, when I was going to school in the 90s, we all were just taught law courses. That's all. When you look at my LLB transcript, it's just fewer law courses. But we were missing a lot of things. Okay. So now law is becoming more and more interdisciplinary. So DNA and forensic science. Today, DNA evidence is an important part in resolving criminal law disputes in courts of law, right? So we, as legal law students and legal practitioners, must be abreast with issues relating to DNA and forensic science, so that we can understand how does it work. Okay, if I'm representing a client and the government chemist has produced a report which attempts to, incriminate my client, I need to be able to understand how was this DNA evidence gathered? What is DNA evidence in the first place? But of course, DNA evidence and forensic science is significant. It's important in resolving criminal law disputes. Another area where we see advancements in criminal law research is in the area of cybercrime and cybersecurity. Cybercrime and cybersecurity. Again, this has been proliferated by developments, societal developments, especially the information technology revolution and cybercrime. This has led to an extensive research in the area. Yeah. So we need to be able to understand the nature of cyber threats, what legal framework should be used to prosecute cyber criminals, and challenges relating to international cooperation and the whole issue of combating cyber crimes. Okay, so here we know cybercrime is one of those criminal behavior that are committed transnationally. Okay, so in one jurisdiction to another. So it's very important for criminal law research to understand how to respond to such challenges. Other areas relate to criminal profiling and behavioral analysis. Again, I spoke a bit about criminology as a social science, but there are many other subjects that are important within the realm of the legal framework to be able to understand. And I believe they make a contribution in the advancement of criminal law research. We have international criminal law. Okay, so international criminal law, as we all know, is I normally like to say is the is the sibling of national criminal law. But international criminal law is an important advancement within criminal law research because it focuses on specific criminal behavior that we call international crimes. Okay, and these are genocide, crimes against humanity, war crimes, and the crime of aggression. And the fact that there is a supranational judicial institution that can deal with responding to such criminal offenses. As we all know, the jurisprudence of the International Criminal Court, the Rome Statute provides for the doctrine of complementarity, which states that national courts have primacy. The International Criminal Court will intervene only when national courts are unwilling or unable. But this is a huge area in the advancement of criminal law research. There are other areas like restorative justice. Restorative justice is a theory of justice that focuses on restoring the rights and responsibilities of a victim of crime. Okay, restorative justice believes that when a crime is committed, the perpetrator and the victim are not in the same level. So restorative justice attempts to bring the victim to the same state of affairs as the perpetrator before the crime was committed. But the focus mainly is on the victim. And so this is another huge area in the advancement of criminal law research because we've started to see the implementation of restorative justice in the mainstream criminal justice system and in criminal courts in general. Other areas relate to sentencing and rehabilitation programs. I don't know how many of you know, but Kenya is one of those few jurisdictions in the world that states, and if you read the Prisons Act, which is, I think, Chapter 90 of the laws of Kenya, which is now in the process of being amended, it states that the purpose of punishment in Kenya is rehabilitation. So one would want to ask, how did the legislature come up with that provision? Why would they say that the purpose of punishment in Kenya is rehabilitation? So the focus more is on rehabilitation. So this is again another area where criminal law research can enrich in understanding the purposes of punishment. Why do we punish? You all know the introduction of the sentencing guidelines policy, which emphasizes on, puts a little bit of emphasis on non-custodial sentences rather than custodial sentences. So this is another area where there is an advancement in criminal law research. Others include mental health and criminal justice. Yeah. In other jurisdictions in the developed world, there's this huge debate. What do you do with people who commit crimes because they are addicted to drugs or they are homeless? Okay, should they be adjudged and sent to prison? Yeah, to serve a custodial sentence. In jurisdictions like the US, they have actually come up with drug courts. Okay, so these are specialized courts that deal with issues with individuals who are considered addicted to drugs, and it's not a normal court. Okay, the judge plays a role of a counselor, yeah, a psychologist, and try to make sure that they respond to the needs of these individual persons. Another area, again, I said my list is not exhaustive, but environmental and white collar crimes. Environmental and white collar crimes is another area where there is an advancement of criminal law research. We all know what white collar crimes are, and there is also debate within the scholarship as to whether what happens to white. We know that white collar crimes are committed by individuals who have means, powerful individuals. But most of these individuals don't end up spending a day in prison. Yeah. So white collar crimes include corruption, money laundering, and all these other things. So it's important for criminal law researchers to explore, the legal responses to white collar criminals. And this goes to the point that I raised in the beginning, that when you go to Kamiti prison or Langata women prison, individuals that you see are mostly poor people. And it begs the question as to whether it's only poor people who commit crimes. Let me try to, okay, so I think it's sharing now. uh Let me go. Okay, good. So let me see if it will show the other slide. Okay, so this is the slide I was talking about the advancements in criminal law. So these are the areas that we see a lot of interest, criminal law research interest in these areas. So the third question is, what strategies are there for effective legal writing? I know all of you will be required to write a research paper when you before you leave your training. It's also known as a dissertation. So it is important as you think about your topic, and I'm not sure what years you are, but it's important to start beginning thinking, what should I conduct research on? Yeah, because the early the better. It allows you to brainstorm on possible areas and start thinking of a way in which you will go about conducting the research. So here are some of strategies for effective legal writing. Number one, and this is what we all were taught in law school and in other trainings: understand your audience. It's very important. Who is reading your document? Okay, is it a judge? Is it a client? Is it your colleagues? Is it your law professor who has given you an essay to write your exam? Yeah. So you need to tailor your writing style and tone to suit your audience, especially the level of expertise and expectations. That's very, very important. You need to understand your audience. A second point, I think, is to organize your thinking, because that's what I also encourage you now as you think about your research paper or dissertation. Organize your thoughts, provide an outline, yeah, identify key points, organize them logically, yeah. And remember that legal writing follows a very strict standard, a structure which requires to be adhered to, and all the formatting requirements. Now, in the Q&A, I'm also going to ask you some few questions. This has to do with issues of citation. Okay, so what citation format are you using in your law school? Okay, is it the Blue Book? Is it the Harvard citation? Is it MLA? Is it the APA, which is mostly used by social scientists? Use clear and concise language, and this is very important. This reminds me of my law professor who passed away he was my mentor and my friend. Passed away this year. He had already retired from teaching after teaching in university for 40 years. He used to tell me, Simeon, use plain language. Okay. Sometimes we think that the use of plain language perhaps reflects on our being unsophisticated. Okay, we use verbosity and redundancy to show how sophisticated and educated we are. That's wrong. Okay, so even in legal writing, you need to use clear and concise language. Okay, use plain language whenever possible. Avoid legalese. I know. Here in, what's this other one which I really don't like? There's one I don't really like, and it's used by even lay persons, yeah, to show how sophisticated they are. But that's not good writing. Okay, so clear and concise writing is what is is advised. Do not use complex jargons. Okay, because that can confuse your audience. Even for a sophisticated reader, maybe you're writing a brief to a judge. It doesn't mean that you should use difficult language. So plain language is advised. Be precise. Okay, define legal terms. Yeah. Cite relevant statutes. Okay, avoid ambiguity. Vague language will not really help you, will not help the case you have before the court as you advocate for your client. If it's in your essay exam, it won't really help you in getting more points. Okay, so again, be precise and to the point is one of the other important points that I emphasize on effective legal writing. Okay, others are, as you can see, the use of headings and subheadings. It's crucial because that provides a guide to a reader to know, okay, the writer, the author is going from this point to this point. Okay, cite sources properly. This obviously avoids plagiarism. um, Borrowing ideas from others and adapting them as your own. I've talked about verbosity and redundancy, which is again a no-no. Provide context. Okay. Ensure that your reader understands your train of thought. Okay. What argument are you making, and why are you making that argument? Always provide a summary. I believe you guys know what IRAC means for. IRAC, issue, rule, analysis, conclusion. So this is the basics of legal writing. Make sure that you have someone can go through your work and have a clear understanding of what you're thinking. Okay, so provide a context. Others include the use of transitional phrases. Okay, it's also very important. This is basically one-on-one in writing, not just only legal writing, but writing in general. Use transitional phrases. Transitional phrases are, for example, however, therefore, in addition. Okay, and you'll see this especially when you're writing your literature review. When you're writing your literature review in your for example, legal writing, be it your research paper or even articles, it's not enough to just list what author A said, what author B said, what author C said, but to show how these ideas between author A, B, and C are connected to each other. So one best way is to use transitional phrases to connect the ideas together. Objectivity is important. Okay, so avoid emotional language. Okay, avoid emotional language, avoid personal bias. Always attempt to be objective. And how can you do this? You can be objective by focusing on facts, the legal arguments, the evidence in a neutral manner. Okay, because remember, you must and here I have address counter arguments. You have to be producing your arguments and also counter arguments. And this is one way of showing objectivity in your legal writing. Others are the use of examples. Of course, examples are very important because they allow the reader to see how your argument is related to real world examples. Okay, so the use of hypothetical scenarios are very important in writing, in legal writing in general. Yeah. Seek feedback, very important, and this you probably need to know. If you don't, in our legal profession, we don't work in solos. Okay, so we consult, and consultation becomes key. When you seek feedback, you get a second opinion, and it can even refresh and direct your thinking into a more logical way of thinking. Yeah, so that's why solo practitioners are not a very good idea. Yeah, so that I think emphasizes on the question of seeking feedback, and always stay updated. Okay, staying updated is to know what case law has been overruled. Okay, so that you don't cite an overruled decision. Okay, what are the don't cite a statute that has been repealed. Yeah. So if you cite outdated information, it weakens your argument, and eventually you may lose a case. So it's very important to stay updated. All right. So my last question, my last issue is on some thoughts that I have in concluding my discussion. So what are some of my reflective ideas here concerning legal research, legal writing, and the advancements in criminal law research? So as I said in my opening, I think it is important to embrace the future of criminal law research. Because of this age, unprecedented technological advancements that we have today, the future of criminal law research has endless opportunities and possibilities. Okay, so we need to embrace these tools, these new tools, methodology, and most importantly, the interdisciplinary approach to modern research. Curriculum of legal courses, of law curriculum, for example, in the United States, I'm more familiar with that. Law students today are taught subjects like statistics. Okay, so I know we have improved a bit in our curriculum. As I said, it's not the same curriculum that you guys are learning, the one that I did in the 90s. But again, there's a clear introduction of these very important subjects that inform legal processes. Okay, so like I said, statistics for the purposes of conducting research, and many others. So we need to embrace the future of criminal law research because it has unbound possibilities. The issues of data-driven advocacy. The days where you cite information that is not empirically tested are over. Okay, it's time now to embrace data-driven advocacy, and all policy, all criminal law policy should be, and policy in general should be empirically tested and scientifically driven. We also need to strike a balance in legal writing. What do I mean by that? I mean that, as I said, you guys are going to school in a time where there is a lot of information, and you can be able to access information in a more simpler way compared to when we were going to school. I had to go to the library and punch cards to look for books. Okay, you can easily go do that on your phone. You can do a Google search and find out information about a particular area of law that you maybe not understand. So we need to be able to strike that balance between, as I said, plain language, concise expressions, and persuasive storytelling. Yeah, because that is effective legal writing processes that can allow us to advocate the rights of our clients, but also to be able to make a contribution into the jurisprudence of criminal law and other legal disciplines. I spoke about, of course, technology, but there has to be, we have to also look at the intersection between ethics and technology. Okay, I said police officers, for example, use tech to inform issues relating to criminal behavior. Okay, so what are the ethics of these technological advancements? Okay, in other jurisdictions, police officers wear a camera when they are effecting an arrest. So it is important for us to also understand what are the ethical boundaries related to technology. Another important area to reflect on is this idea of advocating for justice in a changing world. So there are a number of emerging areas within the law, within criminal law research, as I explained, issues relating to cybercrime, climate change, yeah, the evolving notion of justice. I was just reading a book here, and this author is arguing that in today's world, where does the state get the power to punish? Yeah? We live in a democratic world, which means that every citizen is free. Yeah, every citizen is free, and therefore, where does the state get this power to punish? I think it's a very provocative statement to think about. But we also need to embrace lifelong learning. Okay, and this is what some of us have chosen. We've chosen the life of learning, and also transferring knowledge to others. And lifelong learning would help us to advance our thinking in what are new areas in criminal law research, what are the new legal strategies that are available, to make sure that our legal approaches to legal writing approaches and the emerging issues within the discipline are being able to be resolved. Yeah. And I should also remind everyone that in lifelong learning, we're talking about a journey of enthusiasm, humility, and dedication. And that will make a huge difference, and we will be able to make a contribution in the society that we live in. So with that, I think I have come to the end. And if you have any questions that you want to ask me, I again, I get pleasure out of and satisfaction out of interacting with young people, because that's how I was trained. If my professors did not show interest in me and answer questions that I have, sometimes those questions may be obvious or stupid, but they were able to help me understand. And that is what I've embraced as an academic, as a scholar. So that's my email, professorsungi@gmail.com. And I really want to again thank the organizers of this talk, the University of Nairobi Law Journal, for doing this. And I wish you all the best. And Paula, you can take it over. Thank you so much.
Thank you so much, sir. We have indeed taken a lot home, and I think it wouldn't be fair if I close this meeting without allowing the audience to ask some few questions that they may have. So at this point, I'd like to invite those who have questions, kindly raise your hand, and then we can follow an order based on who raises their hand first, of course, so that you get a better understanding of this webinar. Thank you.
All right.
Anyone who has a question from the
I see.
audience?
Yeah.
Oh, you see one. Kivuva.
Mhm.
Hello, can I be heard?
Yes.
Oh, thank you. Thank you, Professor, for the insightful session. Mine isn't a question. However, I'd like to get your views. This follows from the remarks made by His Excellency President Ramaphosa on combating sexual and gender-based violence. Particularly, he was clear that, that the perpetrators of these offenses should be subjected to life imprisonment. And in addition to that, they should not get bail. So they have life imprisonment with no bail. This might be perhaps informed by the need to reduce the neblist environment surrounding the social agency that provides breeding ground for marital and child rape, for example.
Yes.
Thank you.
Oh, that's good. Okay. Paula, maybe we can get three, and then I can, if there are others, and then I will attempt to respond to them. But Queen's question is more of a comment rather than the question. But let me say this. So again, that's why I said it's important for legal training in the 21st century to be interdisciplinary. It is very important for us to be able to understand what are the root causes of crime. Okay. If we are able to understand the root causes of crime, then we can be able to devise, I think, effective ways of responding to criminal offenses. So, suggesting that sexual and gender-based violence, violent offenders are denied bail and they are sentenced to life imprisonment, uh, what is it informed by? Okay. Was there a study that was done to understand what are the root causes of GBV, for example? Yeah. We know that in these types of cases, they involve individuals who perhaps have created a family. Maybe one is a breadwinner. We know that sometimes these issues, these conflicts arise out of very mundane issues that are blown up to proportions that sometimes are unknown. So we need to be able, that's the key. I'm not going to say that life imprisonment, the response is illogical, but I think what I would say is that we need to be able to think what are the causes of these crimes. Yeah. A few years back, there was a proposal in Parliament, I think that was before 2010, of castrating rapists. Okay, there was a proposal, I think, from a member of Parliament that the penal code should be no, the Sexual Offences Act should be amended to include that punishment. Again, the question is, what are the root causes of these criminal offenses?
I'm well guided. Thank you.
You're welcome, Queen. I see Valentine.
Thank you, Daktari, for your wonderful presentation. I only had one concern, actually two concerns. Number one, recently there was a publication in the Parklands Diary by Nelly Maina. She was reflecting, making a case for therapeutic jurisprudence, whereby uh, people accused of attempted suicide maybe due to these mental health issues, they should be really be dealt the same, kind of punishment as somebody who is sane, or maybe we should review our laws considering that aspect. What are your comments on this? Like, yeah, and how can we actualize it now? The second part, how can we actualize it into now, for example, possible policy considerations when we are taking into consideration, especially the mental health of our accused, not only in attempted suicide but also all those other crimes. Thank you.
That's a good question, Valentine. Okay, let me attempt to answer it. It's a good question, but I think it touches on what I said about these emerging issues in criminal law research, the ideas of neuroscience and criminal law. We know that the defense of insanity has been with us for centuries. Okay, we adapted this from our colonial masters, and so what should be the response of individuals that may commit crimes, and there is perhaps evidence that they could not form a necessary motive, yeah, and therefore there is a little bit of neutralizing the mens rea element of their actions. And this is my point, and my point is there's need, before suggesting, before devising mechanisms to respond to crime, we need to be able to understand the nature of these offenses. Why do these individuals, and that's the law doesn't care about the why question. The law cares about the what question. Okay, has a crime been committed? So my argument is we need to go a bit further to explain the why question, because if we answer the why question, then we'll be able to provide an effective prescription of criminal offenses. And therefore, the example I gave in America, they have drug courts now. Okay, so if I'm addicted to drugs, the police arrests me. They are not necessarily going to charge me they will charge me with a criminal offense, yes, but then I won't be taken to the ordinary courts. I'll be taken to drug courts, where a judge works very closely with psychological, medical professions to enable, to cure the deficiencies of this individual. So you said there was a proposal by Nelly Maina on the application of therapeutic jurisprudence. It's a good suggestion. Yeah. Now the problem is the implementation on the say, because what we also suffer is budgetary constraints, and also political. There's no political will. And to me, I think it's because most of us don't understand these things, and we don't take time to learn and understand them. I hope I've attempted to answer your question, Valentine.
Yes, I stand well. I'm well guided. Thank you, Professor.
You're welcome. Okay, any other? I have time. So any other question?
Okay, good afternoon, Professor.
Good afternoon, Lawrence.
Okay. Question is on
Yes.
self-learning lethal autonomous weapons.
Mhm.
We have fears that soon we're going to have self-learning weapons that are directing themselves. So if I want to kill someone, I don't have to even direct an AI weapon to do it. It can learn from the environment and do it by itself. But then there's nothing that's going to link it to me. There is no mens rea on my end, and there is no
Yes.
trails. Are we going to have a gap on responsibility? And I think this is also a concern in international criminal law.
Yes. That's a fantastic question. and it's a tough one. But you brought me to my other cup of tea, which is international humanitarian law. So we have principles of international humanitarian law. We know that war is not a crime. Fighting is not a crime. What is the crime is committing offenses or behavior that is contrary to, for example, the Geneva Convention and the Hague Convention. So autonomous weapons have traditionally been banned because they cannot discriminate. Okay, and they may target civilians, civilian objects and other objects that are not military targets. Okay, and that's the reason why there has been kind of a ban on autonomous weapons. However, your question is, so we are in the age of AI, for example, artificial intelligence, and I want you guys to embrace artificial intelligence. We have a lot of like Chat GPT, for example. It's a good resource for education, by the way. It's not plagiarism. Chat GTP provides you with ideas of how you can frame your thinking. It's not necessarily copying things from elsewhere, because some have argued that this is a machine. I mean, we are not copying ideas from it. We can't consider that plagiarism by copying ideas from a non-human object. Okay, so I believe we still can be able to trace the origins of this autonomous weapon and be able to know who deployed it and for what purpose and what were the consequences of this deployment. So I still think we are not in that age where, maybe robots, even robots, we can be able to tell, who manufactured this, who's this robot representing, for example, and still assign accountability. But I think that the biggest problem here is on the use of these weapons, because they cannot discriminate, they cannot be controlled, and they therefore violate the law of war, because they may target civilians and objects that are not necessarily military objects. Lawrence, is that good?
Yes, that's good. Thank you so much.
Thank you. I see there is John Muturi. I think, John, you can continue. John, you can ask your question. Paula.
I see that his mic is open. I don't know why we can't hear him. Maybe we can give him time to type his question.
Okay, yeah, he can type the question and you can read it.
You can type the question and maybe have one last question before you cap it off. One last question, just one last one.
And Paula, if you allow me, I could also ask one question. And maybe you can respond on behalf of everyone.
Sure, that's okay.
Mhm. Okay, so I see John probably is having challenges. So maybe let me ask my question. So maybe there will be two questions. So question one, what are the areas of law that most of you are interested in? And do you think the LLB curriculum as it is today equips you to become an efficient legal practitioner after graduation? So those are my two questions.
Well, thank you so much for the questions. First, the areas of law that we are interested in. I don't know if I'll be speaking for everyone, but let me speak for myself. Well, I'm interested in commercial law, ADR, and mainly employment law and international trade law. In the second question on whether the LLB has equipped us adequately, um, I wouldn't give it a yes or no answer. I'd say it's a 70-30 thing. 70 in terms of giving us the lecturers are there, they're teaching us well, and we are learning the theoretical bit of it. But you have to go out and seek the 30% from having from exposing yourself and even attending webinars such as this to have a broader spectrum of what is happening on the ground. We recently did our judicial attachment, and it was a touch of reality. It was sort of what you learn in class and what happens in reality, and you started questioning some things. One interesting thing I noted is when you talk about defilement cases and you say the law is the law, and you have a scenario where it's a 19-year-old and a 17-year-old, and the 19-year-old is getting a 20-year sentence, and you question, is this mandatory sentencing really justice at the end of the day? And you get to have such questions because in class you just read like the law is the law. If he does this, he's guilty, and it's just to have him in prison. But when you're in the in the space, you see those things happening, you start questioning your understanding of what justice is. So yeah, that will be my response to your question.
That's a very good observation. Yeah. But there's a saying we have: law in books and law in action. Yeah. So that's a very important challenge for all of you. There's a big distinction between law in books and law in action. So as a good teacher, I have books, okay, that I want to suggest to you. Okay. So some are old editions, but they are very helpful. Now there's this book called On Writing Well. On Writing Well. Okay. On Writing Well. This is not for only legal writers, but for all writers. Okay. This book was published, it's an old book. It was published the first edition was published in 1976, but there were other editions to 1998. Yeah. So on Writing Well, I don't know if you'll have it in your law library. The author is William Zinser. William Zinser. Okay. And he talks about very interesting things here. Principles of writing well, the transaction, simplicity. I talked in my talk, I spoke about simplicity, clutter, style, the audience, words, usage, yeah, and different forms of writing. So there's nonfiction, there's writing about people like interviews, etc., etc. Yeah. So these books, if you are able to interact with them, they can really help you and improve on your writing. Another book that I have, now this one is legal. It's called Just Writing: Grammar, Punctuation, and Style for the Legal Writer. The book I had, this I used when I was doing my LLM. This book was, this is a second edition. I think they have other editions. So Just Writing: Grammar, Punctuation, and Style for the Legal Writer. The publisher is Aspen. Now this is very, very good. This is a very, very good book. The second edition was published in 2005. Now, the table of content here is the guide to effective writing, how to write a whole paper, connections between paragraphs, connection between sentences, effective words, and there is a part, especially chapter 10, which is on legal writing for English as a second language writers, and most of us probably qualify as English as second language. Yeah, so look for this book. It's called Just Writing: Grammar, Punctuation, and Style for the Legal Writer. The authors are Enquist and this I think is Oates, Anne Enquist and Laurel Curry Oates. Okay, so perhaps your library can have these books and you can go through them and help you improve on your legal writing. But I have other books. So, like I said, criminal law is what I drink and eat every day. So this book is called Criminal Law Stories. And this is a challenge to the law journal individuals. And this is what I haven't seen this a lot done in this part of the world. The purpose of law journals and law reviews is to critique, for example, jurisprudence that is created by our courts, case law. Yeah. When the Muruatetu ruling was handed down, I didn't see any. And this is again, I'm also guilty. Yeah. No one wrote a review about it. Yeah. And the implications. Because in other jurisdictions, when the law review, especially in the US, law reviews are very important because they also inform judges in their way they think and the decisions they've made. But also it can influence their changing of their thinking when they are deciding future cases. Yeah? So I challenge all of us to be involved. Let's write journal articles that also not only reflect on general issues general legal issues in society, but also provide a critique to different jurisprudence that is developed by our courts. So I think with that, I am done, unless there's maybe a question, a burning one.
I believe there are no more questions, but your email will be very, very useful, and I'm sure many people will be there with questions they have. So thank you so much for your guidance today on understanding legal scholarship in criminal law. And thank you so much even for the recommended books, which will be a treasure trove of wisdom that will undoubtedly serve as guide spots to our path in becoming accomplished legal professionals. We are sincerely grateful for you and each and every participant in this webinar today. And we can't wait to have more of these webinars and more discussions. Maybe next time we can go into Muratetu if it comes again, or any other criminal law case that comes forth. And we'll be glad to have you here. Thank you so much and have a nice evening ahead. Thank you.
Thank you. Good luck. Good luck in your studies. Bye-bye.